We have an important announcement by Professor McGinnis.
Dean Reuter has asked me, as with other practice group members, to introduce our practice group sessions by saying just a brief word about the practice group itself. This is the International Law and National Security Practice Group, and I think the idea is for us to put in a very brief pitch to get more people to join it and to participate in its leadership. Well, I think just by giving the title, International Law and National Security, one can see why one should join it. You just have to look at the news, the relentless increase in globalization, the continuing dangers from terrorism, to see how central national security is to our lives. And for this panel, we'll look at international law. And as an academic, I have to say that there's no area in the law schools that is more interesting and been more reinvigorated in the past decade than international law. International law seemed a very well-tended garden where most people thought the same things about the structure and generation of international law, but there have been a whole school of people, many of whom are often in this room and on these panels, a group called the revisionists, who have challenged the very roots of international law, either as being inconsistent with American sovereignty, as being poorly generated by the processes which some people think form international law, or in some cases not even really existing, being a phantom of the imagination. So in conclusion, I think it's a very interesting group, both practically for what's going on in the world, but also I think more than any other academic subject where the foundations of the subject are up for grabs. So we'd be delighted if you participated in the group. Thanks very much, Judge Bia.
Thank you. Well, I'm very honored to be able to present to you a distinguished panel that's going to talk about who defines international law. These days, we are increasingly urged by litigants and public servants and professors and commentators to broaden our horizons as to the basis of our decisions regarding national security and foreign relation cases from simply our domestic law. They urge us that we should take into consideration international law. Perhaps they are motivated by the words of our own Declaration of Independence, said in a different context, that we ought to, quote, have a decent respect for the opinions of mankind and apply the law of nations, as appears in the Alien Tort Claim Act enacted by our first Congress. Today we have a distinguished panel of professors and one practicing attorney in the field of international law to address the issues of who defines international law and what role does it play or should it play in the determination of the decisions of our courts. Before I introduce the panel, I should tell you that this panel will be a little bit different from those that you've already seen. There will be no opening remarks by the panelists. Instead, we will have a roundtable discussion. I will ask a series of questions to spur discussion between and among the panelists, and every panelist need not respond to every question. I will call on the panelists looking most eager to respond to a given question or indicating he has a comment. Responses and comments should be no longer than a minute or two in order to keep the discussion flowing. It's a little bit like the Sunday morning panel roundtables, except that, unlike some of our television channels, we have a balanced panel here. Now, the first issue is basic. What are the sources of international law? By that, I want you to feel free to discuss. Well, before we get into that, let me introduce the panelists, because that's going to be very important to you. On my right, I have John Bellinger. Mr. Bellinger is a partner in the international and national security practices of Arnold and Porter here in Washington, D.C. He advises governments and firms on a variety of issues involving international law and U.S. national security law issues. Mr. Bellinger served as a legal advisor for the U.S. Department of State under Secretary Condoleezza Rice from 2005 to 2009. He represented the U.S. before the International Court of Justice in Mexico versus U.S., better known to the followers of the Supreme Court as Medellin versus Texas, involving the requirements of provision of consular services to aliens involved in American criminal cases. Mr. Bellinger also served from 2001 to 2005 as Senior Associate Counsel to the President and Legal Advisor to the National Security Council at the White House. Mr. Bellinger graduated from Princeton's Woodrow Wilson School in 1982 and from the Harvard Law School in 1986. He speaks regularly on radio and television and has lectured at numerous universities on international law. Seated next to him is Professor Ryan Goodman. Professor Goodman is the Aaron Kranz Professor at New York University Law School and founding co-editor and chief of the national security blog Just Security. Previously, he was the professor of human rights and humanitarian law at Harvard Law School. He did his undergraduate work at University of Texas in Austin and law school at Yale. He is the author of many articles and texts on international human rights and human rights institutions, as well as work in the field of reconciling concepts of just war with human rights concerns. He is a member of the Department of State's Advisory Committee on International Law, a member of the Council on Foreign Relations, a member of the U.S. Naval War College's Board of Advisors for International Law Studies, and a member of the Board of Editors of the American Journal of International Law. Next to him and to my immediate right is Professor Lewis. Michael Lewis is the Fisher Professor of Law at Ohio Northern Law School. He is the author of War on Terror and the Laws of War, A Military Perspective. His writings have appeared in many legal journals and have been cited in several courts of appeal decisions. Professor Lewis has testified before Congress as to the legality of drone strikes in Pakistan and Yemen, and on the civil liberty trade-offs involved in trying some al-Qaeda members or terrorist suspects before military commissions. He earned a BA from Johns Hopkins and a JD from the Harvard Law School cum laude in 1998. Before that, however, he served in the U.S. Navy for 8 years, where he flew F-14s from the deck of the carrier Independence. He is a graduate of the Navy's Top Gun Fighter School. To my left is Professor Deborah Pearlstein. Professor Pearlstein currently teaches at Cardozo Law School, following tenure at Princeton, Woodrow Wilson School, and visiting appointments at Penn and Georgetown Law Schools. She has written extensively in law journals and the popular press on issues of international security law and the separation of powers. Professor Pearlstein served as a founding director of Human Rights' first law and security program, where she led efforts in research, litigation, and advocacy regarding U.S. policies on detention and interrogation operations. She has prepared amicus briefs in Supreme Court cases. She has co-authored reports of detainee deaths in military U.S. custody. Professor Pearlstein has worked closely with military and intelligence communities, including off-the-record workshops to address key policy challenges in U.S. counterterrorism efforts. Before her career, she served in the White House from 1993 as senior editor and speechwriter for President Clinton. Magna cum laude graduate of the Harvard Law School, Professor Pearlstein clerked for Judge Boudin on the First Circuit and Justice Stevens on the Supreme Court. Because he's arrived late from California, he has not provided me with a resume as Professor John Yoo, but he really needs no introduction to any of you who have been here for a while. Professor John Yoo is a professor at the Berkeley Law School, formerly known as Bolt Law School, and served in the office of legal counsel during the Bush administration, and has been a prolific author in the field of national security and national policy. So with that, we'll go forward with the first issue, which is, what are the sources of international law? I want the panel to feel free to discuss treaties between nations, customary international law, international covenants and conventions, the Geneva Conventions, international tribunals, and various pronouncements by rapporteurs. John, do you want to start off?
Thanks. Is this on? Well, it'll come on in a minute. Now it's on. Thanks, Judge, and thanks, everyone, for coming. Of course, I will not say that the panel is disappointed that the room has emptied out by about 90% from Senator Hatch, but we'll have a good discussion about international law. As you heard, I served as the legal advisor for the Department of State under Secretary Rice in the second term, so it fell to me to talk about international law to the rest of the world. So let me quickly give the textbook example and then get to the point of what we're concerned about. The textbook answer to what are the sources of international law, it says actually in the treaty that sets up the International Court of Justice, are treaties that are actually recognized by countries. So it's not international law unless you're actually a party to the treaty. Second, the practice or custom of states that are actually followed as a matter of custom, as a matter of obligation, we call that customary international law. Those are the sources of international law. And then as a subsidiary matter, the decisions of national courts or of distinguished jurists. Let me quickly get into, frankly, what I think this panel is really all about is, what is real international law and then what is not international law? Because this was a struggle that I had to spend a lot of time as legal advisor at the State Department. The United States certainly believes that there is international law and it benefits us every day. We are party to thousands of treaties. During the Bush administration, here's a statistic that will surprise you. The Senate approved 163 new treaties that the Bush administration supported. That's more treaties in an 8-year Congress than at any point in American history. During the Obama administration, in the last 6 years, only 13 treaties have gotten through the Senate. That's the fewest number of treaties in American history. So the Bush administration believed in international law, and I can take you through those treaties. We also believe in customary international law. I suspect there are a lot of people in this room who don't believe in customary international law. The difference is a lot of people, a lot of sort of liberal groups or international organizations say that there are things that are in customary international law that are not, principles that they believe in. But there are principles of international law that the United States believes in that are followed by states. And I'll just give you one example, which I think will resonate, and then stop. So, for example, the immunity of heads of state and government. For hundreds of years, international law, by custom, recognizes that the heads of state and government have immunity from criminal or civil prosecution or even being touched in another state. It comes from the equal equality of countries. There's no treaty that says that. The United States or no other country is a party to the immunity of heads of state and government. We just recognize it. So when I was legal advisor, if a foreign head of state were sued in the United States, we would immediately, and I would sign the order, would sign a suggestion of immunity that said that this head of state of government had immunity. We would give that to the courts would recognize it, and the case would be dismissed. And we expect the same thing in other countries because it's all based on reciprocity. That is customary international law. I can tell you at one point, I signed an immunity order for the Pope, for Pope Benedict, who was accused of overseeing child molestation around the world. He was sued in Texas. I signed a suggestion of immunity based on his head of state status of the Vatican. The case was dismissed, and I was pilloried not by conservative groups who were concerned about customary international law, but by liberal groups who said that I shouldn't have been suggesting immunity for the Pope. So we can get more into customary international law, but what I would like to do in the later time is to sort of leave you with the idea that, not all customary international law is bad. There is customary international law that exists. The problem is, groups, organizations, and others who every time they find a principle that they like, then try to say, oh, well, this is customary international law, when it really isn't.
All right. Thank you. As I was listening very carefully to John, there was a subject matter or a phrase that I didn't hear come up. And so I'd like to ask Professor Goodwin and Professor Perlstein if they would amplify as the sources of international law as to human rights law.
Sure. Thank you, and thanks again. I share John Bellinger's appreciation for your hosting us and for having this panel. So, broadly speaking, John Bellinger and I are exactly in the same position with respect to the sources of international law, right? There are two primary sources, treaties and customary international law. Treaties are international law in the sense that they reflect the views of at least two parties. They're also our law in the United States. The Constitution provides for treaties. The Constitution calls treaties the supreme law of the land. And our Constitution provides a mechanism under domestic law for how we go about ratifying treaties. So to the extent the United States is bound by an international treaty, it is bound because it has consented to be bound by it and has pursued the constitutional process for ratifying it. Customary international law, as John said, is different and is the subject of a world of debate that perhaps we can discuss. But there I broadly, even as a former human rights lawyer, broadly agree as well. There are certain things that are absolutely customary international law that every state, I think, essentially every state would agree. And some of them are human rights prohibitions. The prohibition against genocide, the prohibition against slavery, for example, are the first that are usually listed as among the customary international law. Protections of human rights, those are also the subject of treaties that the United States has signed and ratified. So I quite agree with the statement of where you find international law. International human rights law, like any body of international law, whether it's international trade law or the law of war or international environmental law or international intellectual property law, has the same sources that it draws on. So there are a host of international human rights treaties, many of which the United States is party to, most famously a treaty called the International Covenant on Civil and Political Rights, which, if you read at least the first half of it, looks and sounds an awful lot like our own Bill of Rights in many respects. But there are a set of international human rights treaties. The Convention Against Torture, which the United States was recently making a presentation on, is one of them, the Genocide Convention, and there are others that you would, I'm sure, recognize. So that is, treaties are, I would say, the primary source of international human rights law. There is also customary international human rights law, and some of it reflects the prohibitions that I've described already: genocide, slavery, torture is usually considered among those three, among that group as indisputably part of customary international law. And I agree with John as well. There are other pieces. There are both advocacy groups and scholars and others who would claim, well, we should include among a prohibition, a customary international law prohibition, other practices by states, aspects of religious freedom, for example, and others. But I am an adherent to the traditional definition of what counts as customary international law, and that is a general and consistent, widespread practice of states. That is, you have to show most states actually do this, or don't do this, as the case may be. And you have to show what's called opinio juris, the idea that the reason states are doing it is because, or not doing it, is because they think they are legally bound to do it or prohibited by it. The example I would cite is diplomatic immunity, for example. So this is a prohibition or protection that's existed for centuries, if not millennia, and it remains not only the subject of treaties, but also customary international law that the diplomats of one country enjoy protection in another. Having said all of that, and I think those are broad points of agreement, I want to distinguish, before we move on with the rest of the conversation, what I think is not international law, beyond what we've just defined, that I hear people sort of mistaking quite regularly. One is foreign law. So, for example, the property law of France, right, or the constitutional law of South Africa. Every country in the world has its own body of law, right? This is what we talk about when we say talk about comparative law, comparing one country to another. This is what the Supreme Court sometimes cites in helping elucidate its own decisions and its opinions. Well, our law is unlike the law of the UK in this respect, for example. But foreign law is not international law. Nobody thinks it is, and nobody would suggest the United States is bound by foreign law in any case, unless, for example, you're interpreting a contract in which the parties have provided that the contract law of France will apply. The second distinction I want to make is between the substantive laws, on which I think there is actually a vast amount of agreement, and the mechanisms for enforcing those laws and the institutions that enforce them. Just as in the United States, we have a body of law that may be enforced by state courts in one case and federal courts in another case, laws that often don't come to court at all, laws governing, for example, the conduct of the executive in various respects, and some laws that are handled by executive agencies or bodies that aren't judicial bodies at all. International law has the same set of institutions, or a comparable set of institutions, some of which are judicial institutions, some of which are political institutions, many of which are domestic institutions that enforce international law in one form or another. And there is a great deal of controversy surrounding the wisdom and effectiveness of these institutions as well. But that is a different question from the question of what the substance of the law is. So as a definitional matter, I think I'll stop there. Ryan, do you want to?
Anybody else want? Professor Goodman?
Sure. I'll just jump in by saying actually I agree with both speakers in outlining in a certain sense what I think is almost a conventional understanding of international law, and I agree with that as well in terms of the sources. But if you're trying to think through what are maybe the more controversial dimensions of what might be considered custom, then I think, to convey to you all an understanding of what international lawyers themselves might debate about are questions such as, well, how does a General Assembly resolution count? Because a General Assembly resolution is not state practice, and so far we've gotten this definition, which is the conventional definition you'd pick up in any Horn book that says customary international is state practice, widespread, followed out of a sense of legal obligation, but then you get courts, and federal courts in the United States, referring to General Assembly resolutions, or the General Assembly has voted to condemn torture. And how does that count, and why is that in the mix, is one of the questions that gets asked. And the second question that gets asked, and I think part of our conversation is going to turn to the laws of war, or how do military manuals count? Because the International Committee and the Red Cross conducted a multi-year study on what it determined was customary international humanitarian law, and relies in large part as a source military manuals around the world. But in a certain sense, military manuals are pronouncing states' sense of their legal obligations, but do they really count as state practice? And do you actually want to put the burden on states that whatever they put into their military manuals will come back to constrain them at another time? So I think those are some of the controversies that we might try to think through, because it's not so easily packaged, in that there's some debate about what exactly now counts as a source, as a definition or component of custom.
In a moment, we'll come to, on the next subject, will be the role of the various international bodies. But here, just let's concentrate on the source of international law. John, do you have anything to add?
Sure, sure. And I wanted to thank Judge Bea for his off-the-cuff introduction. Sometimes when I speak at places, I don't get the nicest introduction. So I think I'm never going to send my biography anywhere and just let the moderator make it up on the fly, because that was much better than what I deserve and what I'm used to. So thank you, Judge Bea. And I want to thank the Federal Society for inviting me to speak on this panel. So I just wanted to draw a distinction between domestic law and international law, because I agree that treaties are certainly a source of law, and they're a source of law for both international law and a source under our domestic law because of the Supremacy Clause. But I think the customary international law part of it is very difficult. It may be the case that customary international law is binding on the United States. I don't think that's a question for our own domestic legal system. I think that's a question for John Bellinger's former office. The State Department and the legal advisor, in my view, play the primary role in figuring out what customary international law is and what we should be bound by legally, because to me it seems like a part of carrying out foreign policy. And one of the other big debates we have in the Academy is whether customary international law which is, I agree with the definition, it's a sort of Hornbook definition, it's a practice of states taken out of a sense of legal obligation. I don't see whether that should count at all in our domestic legal system. Where does customary national law ever appear? In our supremacy clause, in our definitions of what federal law actually is. I think that's something we've been debating for many years. My personal view is that it's not law until some positive action is taken by the United States government through our federal lawmaking processes to make it international law. And I think that's why, I think that really points out this concern that several people mentioned about the way customary national law is made, because maybe there was a stronger case once when customary national law was the practice of states for long periods of time. But when it's now UN General Assembly resolutions mixed with the reports of groups which aren't even representing governments and international courts and bodies, I don't see why our federal legal system should give any deference or place of privilege to anything any of those groups say, anything that the UN General Assembly says, or anything the UN special rapporteurs on this or that say, because I think those too are mixed with various agendas and foreign policies. To give you an example, I was looking at the report. So one issue where this comes up, I think, quite clearly are whether drone strikes are legal, as carried out by the Bush administration and the Obama administration. The UN has carried out numerous special reports and studies of the use of drones, which I think have come up with very tendentious and attenuated claims about why these violate international law. So there was I think a well-reported one last year in September where the UN representative said, deploying drone strikes as a form of global policing undermines international security, I love this part, and will encourage more states and terrorist groups to acquire unmanned weapons. So I guess if we didn't use drones, Al-Qaeda is going to stop their plans to deploy drones against us. And it says, the expansive use of armed drones by the first states to acquire them, if not challenged, can do structural damage to the cornerstones of international security and set precedents that undermine the protection of life across the globe. Now, I think those are a lot of statements that have nothing to do with the interpretation of law, but are just a series of policy statements by someone who opposes, the policy of the United States on the use of drones. It's going to be the policy of a lot of other countries, our competitors and rivals in the world, to use drones. But I think that these kinds of statements is fine if this special rapporteur wants to make them, if NGOs and different groups want to make them. I don't think they deserve any place in any kind of making of international law, unless it's for a diplomatic purpose. Legal advisors or secretaries of state think we have to cooperate with them. But I think that's a matter of foreign policy, not really what we should consider law.
Thank you very much. John touched on the next subject, which is going to be what are the roles of various international bodies in the development of international law? Do some have more weight or prestige than do others? For instance, the International Committee of the Red Cross, which has been mentioned here. For instance, the International Court of Justice, before whom John Bellinger has appeared. For instance, the European Union for Enactment of Rules and Engagement of War. So why don't you lead off, John, and tell us what are some of the international bodies that develop what we have styled international law, and are some more weighty than others?
Well, I want to quickly turn things over to Michael, who didn't get a turn, so he can, I think, jump in on some of the laws of war. I mean, certainly, I agree with John that there are lots of groups that purport to interpret international law, say what international law is, and then others pick that up and say, oh, that's international law, and that then falls to us in the U.S. government to separate the wheat from the chaff. And there's a lot of chaff, and there is some wheat. And we have to do that every single day. I have spent more time and more meetings with tens of thousands of European groups and international organizations and UN rapporteurs and different committees, telling them very firmly, when they would tell me, oh, this is you're violating this international law principle, just saying, no, I'm sorry, that is not international law. That is a principle that you like. It may be a worthy principle, but that's not international law. This may be where I disagree with John a little bit. It's fine to take aim at these. These UN rapporteurs don't bother me. This is sort of, sticks and stones may break my bones, but this is not international law. We find it irritating and annoying because the New York Times picks it up and they will give it a headline that says, UN concludes US violating XYZ treaty. And we find it irritating, but it's just wrong. So it's not international law. Some groups, though, as the judge says, are more worthy than others. The International Court of Justice, we have agreed by the UN Charter to comply with its obligations or with its decisions when there is a case between us. The ICJ doesn't set precedent for everybody else. If we bring a case before the ICJ and it makes a decision in which the US is involved, we are required to comply with it. So we complied in the Medellin case. All 9 justices of the Supreme Court concluded that the decision of the ICJ in the Avena case, which involved the 51 Mexican nationals on death row who had not been given their Vienna Convention consular notice, that decision, even though we disagreed with it, was binding as a matter of international law. Now, they concluded that it was not self-executing as a matter of domestic law, but that was certainly a source of international law that we continue not only to be authoritative, but actually binding. The ICRC, we think, is worthy of great respect, although their statements about the Geneva Conventions are not binding upon us. I'll quickly turn to Mike to tell you more about that because it's his areas of expertise. And then you sort of go downhill from there. We have 20 different UN rapporteurs who are experts in their area who I have respect for because they have some expertise. But when they go and say something, they are often wrong about international law, and whatever they say is not binding on the United States. So it actually doesn't trouble me terribly other than sort of as a PR matter.
Mike, you want to pick up on that?
Yeah, no, as an academic, it ends up bothering us more because the special rapporteurs say things that then we either agree or disagree with, and then we are either right or wrong because the UN said so, arguably. But the ICRC does have sort of a special place among these NGOs in that they are, I guess, keepers of the flame for the Geneva Conventions. Geneva Conventions, of all of the international agreements, they are the only international treaty that has been universally ratified. Every single state in the world has ratified the Geneva Conventions, and so they hold sort of a special place there. And the ICRC has all along been very important in interpreting and expanding and following up on and then implementing, to the extent they are able, the provisions of the Geneva Conventions. But the reason why even their pronouncements or their interpretations of the Geneva Conventions or the laws of war broadly are not entitled to legal status is because they are not a state. And that's what it has to come down to, in that, and everybody else in the panel has already said that, so I'm not going to say it again, but states are the only ones that can make customary international law. And I want to give one quick example as to why this is the case. Back in 1987, so the Geneva Conventions were passed in 1949. In 1977, you had the additional protocols 1 and 2 that were updates to the Geneva Conventions to try to modernize them for more modern warfare, guerrilla warfare, internal conflicts that were more prevalent, that looked a lot less like World War II, which is what the Geneva Conventions were originally designed to deal with. And so 1977, the additional protocols. In 1987, President Reagan sent over to the Senate a recommendation that we ratify Protocol 2, but not Protocol 1. And in response to that, the legal director of the ICRC, and Reagan's reason for doing this was saying, look, additional Protocol 1 is giving greater protections, greater rights to terrorist organizations, to irregular armed forces that don't generally abide by the laws of war, don't carry their arms openly, et cetera, and that is a problem. And the United States objected to that and said we can't fix this through reservations, we should not become a party to this treaty. So the legal director for the ICRC wrote an article urging the United States to ratify Protocol 1. And in this he said at the outset, we should recall that Protocol 1 is applicable only to international armed conflicts It has nothing to say about non-international armed conflict, civil wars, any situation short of war, internal strife, or any other manifestation of violence. Terrorism is much more rife in situations other than international armed conflicts. So the ICRC is saying, go ahead, please ratify Protocol 1 because it's not going to be used to protect terrorists. It's not going to be used to criticize the way that you go after terrorists because those are not international armed conflicts. You fast forward to the war against terror, where we are fighting al-Qaeda, a conflict that the U.S. Supreme Court in Hamden specifically said is a non-international armed conflict, and yet you have human rights organizations, including the ICRC, saying that Protocol 1 should apply, that the laws of an international armed conflict should end up applying, as custom, to the non-international armed conflict with al-Qaeda. Now, it is far harder for a state to take an about-face like that. If a state takes a position, it is bound by that position, and for it to renege on that or to change that position comes at a diplomatic and political cost. Far easier for the ICRC to say something like this, please ratify this convention because it's not going to be used to criticize counterterrorism efforts. And yet, all of the criticisms of what Israel is doing in Gaza, the fight against Hezbollah, and most of the attacks that we have used against al-Qaeda in Afghanistan or Pakistan or Yemen, most of those criticisms come from alleged violations of Protocol 1-like rules rather than anything dealing with non-international armed conflicts. And so it's because the ICRC is not a state, it's easier for them to change their position on that with far less cost. And that's a reason why I think we need to be more careful about allowing or considering their statements to have the force of law, and that's why they shouldn't.
Mike, could you fill us in a little bit about the substance of Protocol 1?
Well, the most important part of Protocol 1, and this is the part that we do recognize as customary in international law, is the ideas of distinction and proportionality. So proportionality says that any attack that you make must not cause excessive civilian casualties or successive civilian infrastructure harm in relation to the military advantage gained. Now, it's kind of like comparing apples and oranges, but there is a way of supposedly taking into account how valuable militarily is this target, and then how much damage are you doing to civilians and civilian infrastructure. And it cannot be clearly excessive, the civilian harm cannot be clearly excessive in relation to military advantage gained. And the other principle that is very central to this is the principle of distinction. And distinction says that you must make efforts to distinguish between the civilian population and legitimate targets in the law of armed conflict. Easy legitimate targets are military in uniform. The harder ones, and this is probably a phrase we're going to start using during this panel, are civilians who are directly participating in hostilities. A civilian is immune from attack and immune from being the target of attack under Protocol 1 until they begin to take part in hostilities. If a civilian participates in hostilities, then at that point they lose their immunity. And so that's why direct participation in hostilities is important, and the question is, what constitutes direct participation in hostilities, and what is the for such time meaning of that? In other words, once I put the rifle down, am I now immune again? Or do I have to put my rifle down and go home? Or do I have to put my rifle down and go home and not come back the next day? Where in there do I reacquire my civilian immunity? And that's another important question that the Protocol 1 has out there, and that's also recognized as customary international law by most involved.
Thank you very much. I think this leads on to the next section of the talk, the roundtable talk, which is application of some of these concepts that we've been talking about to concrete situations, some of which have been mentioned. For instance, the targeted killing and use of drones. John, do you want to talk about that?
Yeah, I do want to talk about drones. Can I just make one more point about the...
Okay.
Because I actually want to make the case against even recognizing ICJ opinions and some of these other bodies like the ICRC, because I do think that we may suffer from this misconception that there are these neutral bodies, or that they're set up by the UN Charter, so they're going to be more fair in some way than some of these other organizations. I think one thing that, we just heard a speech from Senator Hatch about the problems with the administrative state, and I think one diagnosis of the administrative state domestically that has got to apply, it seems to me, to international organizations is that they get captured by interests, and that the less political control there is over them, the more they're going to pursue their own agendas. I think this goes ultimately to your question, because I think these institutions that even things like the ICJ and the ICRC have their own political or ideological legal agendas that they pursue through these mechanisms. Like the quote I read from the drone report, I think here are different interest groups, different non-governmental organizations want to use the mechanism of customary international law to try to create law that's never really been approved by any state. And I think that's going to be subject to the biases that you would expect any kind of institution that's trying to wield some form of power is going to suffer from. I think drones in particular are a good example, because I would say the way to think about drones is that they are a new kind of military technology, but the legal rules, why should they be any different than the rules we've already developed that apply to pilots fighting jets that drop bombs on targets? Right? But yet I read the passage where suddenly drones have become this dire threat to life on Earth, right? And to global security. I think that really reflects the agenda, the ideological agenda that some of these groups have. The second thing I'd say about the drone issue is that the better way that I think this process should work is that you should have the nations in the world that are using drones, that are fighting wars, eventually going to sit down and agree on rules that should govern their use. But that takes time after you have experience with the weapons and you can see their costs and benefits. But what I think makes very little sense is to try at the very beginning to suddenly come in and say, oh, international law just bans them completely. And I would just point to the history of warfare in the 20th century for lots of examples where this was attempted and failed quite miserably. It's only after there's been experience with weapons that you can have this kind of nation states sitting down, making a treaty that really governs their use. I think the last thing you want to do is allow this kind of vague process where non-governmental bodies, even bodies from the UN, sort of wing it and try to come up with rules that are never approved by the nations that are actually using the drones, and nations are even fighting wars.
Deborah?
Yeah, so there's a lot on the table now, and I want to try to sort out, because I think there's more agreement, perhaps, than seems apparent. First, on international organizations, and there is no question, and I don't know anyone who argues otherwise. Otherwise, I've clearly not been talking to the right human rights lawyers. There is no question that what NGOs say, what law professors say, is not binding law. No NGO I know, including the ICRC, suggests that what they say is binding law. A lot more people would try to be law professors if, in fact, what we said was binding law. It would be a perk in my package I was completely unaware of. So I don't think anyone actually argues that. No court has ever embraced that view of which I'm aware. No government certainly would endorse that view, and well, they shouldn't. But these organizations, without suggesting for a moment that they bind anyone with their expression of their views or their advocacy positions or their research or their arguments about what counts as law and what doesn't, these organizations play a valuable role, just as interest organizations and expert groups play a valuable role in any area of human endeavor, including areas of human endeavor that are legally intensive, and you can pick your regulatory regime. You can agree with what an NGO says or not, you can give them money or not, you can argue against them or not, but there is no sense, they don't think, and no one else thinks, that what they say or do is going to be controlling authority in any sense. That said, let's distinguish some of the other international decision-making and enforcement bodies that do exist. So one category of body is an international court, of course. These are, generally speaking, created by treaties to which the United States is a party or we're not. If we're a party to the treaty and we have agreed to be bound by the decisions of that court, we are bound by the decisions of that court because we have asked to be bound by them, right? For no other reason. The United States is a party to the UN Charter Treaty, as is every other nation on earth. An annex to that treaty creates the International Court of Justice, the ICJ, and we have agreed that we wish to be bound by decisions in cases to which we are a party, right? The ICC, the International Criminal Court, which is often discussed, is another international court created by treaty, to which the United States is not a party, and we are therefore not bound by its decisions. So there's a long list of international courts, and the answer is it depends. Are they binding authority or not? What does their essentially jurisdictional provision say? There are also, as a separate category, not courts, but what a lot of people would call treaty bodies, different kinds of organizations created by treaties. Again, you can pay attention to them or not, depending in the first instance on whether you're a party to the treaty. But many of these bodies don't serve and are not designed to serve an adjudicative role. They're designed to serve something like an advisory role, an interpretive role. Many of them are monitoring bodies like the IAEA. And so a lot of the human rights treaties that we've discussed create treaty bodies. They're not meant to be courts, they're meant to be bodies that say, in our expert opinion, here is what we think. Now again, you can take them or leave them. Many courts in different countries, and some in our own, find them persuasive authority, just as courts would find persuasive authority the non-binding opinion of the executive branch or the non-binding opinion of some other expert that they consult in their process of adjudication. But that's the role that they serve, and they do not suggest, and no one else I know suggests, that these are binding in a legal sense. Okay, so that brings me back to drones and what laws apply and what should apply and who says what. The opinions of the UN Special Rapporteurs, I would say, very much like the expert treaty bodies, are interesting, they're informed, they're important to look at and consider. Ultimately, you reject them or not. The United States government might find them irritating, but not more than that, right? And it's a burden upon the US government, as with everything else it does, to say, we disagree with this for the following reasons, right? If it doesn't embrace them, or ignore them if it wishes, and bear the political consequences of that through the development of public opinion. But the law that exists, the substantive law that exists, the law of war, also called international humanitarian law, also called the law of armed conflict, does apply to the use of drones. The United States government says it does apply to the use of drones, as with any other military weapon. The question and the reason so many in the human rights community and in the UN and so forth are concerned with their use is because so much of their use is secret or is surrounded by secrecy. So critical questions, who are we targeting? Who do we think counts as a direct participant in hostilities that Mike Lewis was just talking about? Those questions have been essentially impossible to get clear answers to from the US government because of the secrecy. So if you ask me, gee, is our drone targeting program lawful? I have to say in all candor, I'm not sure. I don't know who exactly we're targeting. Some, I think I understand who we're targeting, others don't. Until very recently, I would have been hard-pressed to tell you what exactly we think is the scope of the armed conflict that we're fighting in that gives us the ability to engage in this targeting. So those are substantive legal issues, again, distinct from all of these questions of enforcement bodies and organizations and domestic courts and so forth. But substantive law that, again, there's broad agreement at the UN and the US and the human rights community, these laws apply. The question is, how are they applying and what exactly are you doing? And without knowing that, it's been impossible or essentially impossible to evaluate effectively whether we're violating the law or not.
Ryan, you had...
Sure. So I just want to say one brief note about special rapporteurs and then jump into the question of drones targeting and the laws of war. So in the question of the special rapporteurs, I actually agree with most everything, or everything that John has said and most everything that Deborah said. And think of the special rapporteur, especially on the drone report, and it might be the drone report that John used referencing, as almost a catalyst for states to then discuss the issues. So when the two rapporteurs presented their reports on drones last year, it was actually a high moment in a certain sense for political discussion at the UN so that states could mark out their legal positions. And I think that what was most important for sources of law was what states then said. It wasn't what the special rapporteur had said, but then understanding that the US came out strongly with a well-principled articulation of its legal position. I thought that was a very good function of the rapporteur in a certain sense. On the question of the application of the laws of war to US counterterrorism, I kind of see it, I actually almost see the very flip side of what Professor Lewis had said. The way I think of it is, prior to 9/11, it is true that the Reagan administration didn't want to ratify the first additional protocol because we didn't want to apply it to terrorists and embolden them or ever think of them as combatants. But after 9/11, we embraced the laws of war as a matter of custom because we thought of our targets as combatants and should be tried as combatants before military tribunals and the like. So today, the United States, I think it is very consistent with US foreign policy and US counterterrorism policy, targeting in drones, to in fact say we are embedded in the laws of war. And the laws of war are the appropriate legal standard for determining the legality of drone operations around the world. And then I also agree with Mike in the following sense that the ICRC, I see it as a reversal. The ICRC is not trying to constrain the United States through imposing additional Protocol 1 of the laws of war. In fact, the ICRC is going a very different route than they did pre-9/11. In pre-9/11, they try to impose humanitarian laws of war. Now, I think they're actually trying to say, no, you have to apply other law, which would fill in, what would fill in the void is human rights law. And they say, for example, the United States is not in an armed conflict because it doesn't rise to a level of severity. Well, that was kind of knocked down by the US Supreme Court and others. Then they've argued you're not in an armed conflict because an armed conflict has to be between two parties, and Al-Qaeda is no longer a party because they don't have the level of organizational complexity to be a party to a conflict. Also trying to kick out the laws of war. Or another one is that the ICRC tries to argue that the United States can't be in a transnational armed conflict, that even if we do use force, we have to use force within a particular country. So you have to use it within Afghanistan, it can't cross over into Pakistan. And the US position has been, I think, on all of this, the laws of war apply, and there are such things as transnational armed conflicts. I've also taken the position that, in fact, the high majority of internal armed conflicts have transnational effects, in which combatants go over the border to train and the like. But in fact, the United States position has been, this is a part of custom. Last bit about that is, I think in the early days, the way I read it is, that the Bush administration, in fact, endorsed this as a matter of custom because we took the position that the Geneva Conventions did not apply as a matter of treaty. Because if they applied as a matter of treaty, then Common Article 3 would apply. And the US position instead was, no, the laws of war apply as a matter of custom, but we're not bound by some of the particulars of Common Article 3 under the treaty, which the Supreme Court rejected. So another instance in which I think it shows how custom might in fact be very much in the service of what US foreign policy interests are, counterterrorism interests and the like.
Mike, you want?
It felt to me actually more as though, and I agree with some of Ryan's analysis there, but it felt to me more like the ICRC intended to move the war on terror under the laws of war during the first few years of the Bush administration. First few years of the Bush administration, the interpretation of what was going on with Al-Qaeda was it was neither an international armed conflict because it is not between two nations, nor was it a non-international armed conflict occurring on the territory of one party, right? So it fell into a gap, at least arguably, and that's what the government, the Bush administration argued in the Hamdan case, was that it fell into a gap between the two, that the laws of war did not govern necessarily what was going on other than, as Ryan said, out of a sense of custom. So we were going to apply pieces of this by custom, but we were not bound by the treaties because this fell into a gap between them. Stevens's opinion in Hamdan kind of rejected that idea and said, no, you are governed by at least your Common Article 3 obligations under the Geneva Conventions and Protocol 2. Why he then turned around and used Protocol 1 to determine our judicial obligations with regard to our detainees was less clear, but that's how he went about doing it. The only other thing I wanted to say to Deborah's earlier statement about the idea that you don't have organizations claiming that what they are saying is law. You do have, the ICRC put out an enormous 3-volume set in the early 2000s called Customary International Humanitarian Law. And it was supposedly their view, at least, of what customary law was. They went through enormous amounts of military manuals, of state practice, of the history of how the law had developed, and then they came out and said, and this is what the law is as far as we were concerned. And there's a real question as to how much deference that view should be given. But I don't think that there's any question that it should not be viewed as law. Just because the ICRC says this is what we believe custom is, doesn't mean that it's custom. And I know that you wrote a letter to them explaining why you didn't think that it should actually apply.
John, you wanted to chip in?
I did. I was going to make 2 points and then let Judge Bea move forward. So actually, this is a good example on this so-called customary international law study where the ICRC did put together a big study on what it thought was state practice that was in fact being followed by states in war. And in general, it was a quite good study. But in fact, many states did disagree, not with 90% of it, but maybe with 5 or 10% of it, because states disagreed. You know, the ICRC would pick certain principles that they might see states following in war and say, well, we think that that's customary international law. And so the United States and a number of other states then wrote back to the ICRC to say, essentially blow the whistle on them and say, no, prove it. You know, prove that not just 2 or 3 states are doing something, but 194 countries are following a rule out of a sense of binding obligation. And so I wrote back a pretty strong letter to them saying, you know, no, that's not customary international law. So one sort of takeaway here I hope you'll have is that it's basically a hierarchy of groups that make pronouncements on international law, some of which are more worthy than others. The International Court of Justice, of course it's a political body, you know, our courts are political bodies. I mean, everybody's got politics infused, but the International Court of Justice we have agreed by treaty to undertake to comply with its obligations. Then you have these various other groups that say things, and you've heard UN rapporteurs mentioned, you know, that are not binding. I want to mention one example here, though, because we're hearing a lot about it, and you may have just read about this in the New York Times the last couple of days, so it's relevant, is a number of the human rights treaties to which the United States is party, and some to which we're not party, then have treaty monitoring groups where the treaty itself will set up a group of experts. Countries can nominate experts to these groups. The groups then will sit and hear presentations by states defending their records. The United States basically has supported this because it's a way to get, frankly, bad countries in the world to have a light shone on their records. The Sudans and the Libyas and the Syrias and Chinas of the world. Now, of course, what's sauce for the goose is sauce for the gander. The United States then has to go and appear before these same bodies. I can tell you, I headed 10 years ago the U.S. delegation to the Committee Against Torture about a year after Abu Ghraib. This was not the most enjoyable experience in my life. I ended up in all the newspapers and had to, as head of the U.S. delegation, defend the country. And I had to apologize for Abu Ghraib, but basically say, you know, this is not what the United States is all about. So these different groups then make pronouncements, which sometimes they purport to say are binding, or at least they say they're authoritative. And the United States just has to put up with it and disagree with it where we disagree with them. But we do this because we think it is useful to shine a light on the records of other countries. And frankly, this gets back to my point about we just shouldn't be quite so bothered about these things that these different groups say. There are lots of different groups. I get bothered by New York Times editorials, but it doesn't mean that I can abolish the New York Times. So, for example, and I'll turn it back over to Judge Bea, one of the reasons that the Senate 2 years ago voted down the UN Disabilities Convention was that they were concerned by statements that would be made by the treaty monitoring body that monitors compliance with the Disabilities Convention. And the thing is, you know, these groups, say things that are just not binding on the United States. And so we just have to put up with it. But the utility of becoming party to a number of these treaties for the reciprocal value of being able to put pressure on other countries can be quite useful. And I'll just sort of end with a quote that some of you all may remember about what Henry Cabot Lodge said about the UN generally, and I think it can apply to some of these treaty monitoring bodies, is that the UN was not intended to take us to heaven. It was set up to prevent us from going to hell.
John, you had a comment?
Yeah, I think actually it's not just non-governmental organizations that are causing the irritation, but it's also actually formal bodies. So the ICJ, I think John and Deb said, they're quite right. The ICJ purportedly only binds us to decisions we're parties to. But the ICJ, I think, is one of a number of institutions, so their bias is always in one direction. So it's not like our domestic courts where Republican appointees and Democratic, if we're allowed to talk about them that way, might rule one way versus the other way in terms of judicial ideology. I think there's this one-way ratchet in the bias. So to give an example, has the ICJ ever issued recently a pro-Israel decision? In fact, they issued the decision about the wall when there was no party at all, right? It's a request for kind of the views of the ICJ by the General Assembly. The ICJ is the highest authoritative interpreter of international law. But I think it's equally biased. I think it's just as biased, and I don't think there's this distinction really between what the NGOs are up to and what some of the judges on the ICJ are, so on. Another decision might probably be the nuclear weapons decision. Another one, there were no parties, but the ICJ came very close to declaring nuclear weapons illegal under customary international law. They basically said they mostly were, except when the security of this, not to say that the life of the state is at odds. Again, I think that's a demonstration of some of these international bodies, not just groups, but bodies pushing in a certain direction. And that leads me to this next question. Maybe it does segue to the next topics. Is this view of customary international law, I think, itself has a kind of bias to it, or a sort of one-way ratchet to it. So I ask, so for example, the question that Mike Lewis was talking about, the additional protocols and American acceptance of them or not. We refused to sign the treaty. What if the current administration said, as American customary international law, we accept all of the additional protocols? Can the next administration say we change our minds and we don't? Could the Ted Cruz administration retract the Obama administration's acceptance of, as a matter of customary international law, and change it backwards? Or do we see groups and international institutions always pushing international law, always in this one-way ratchet where it can never be changed in another direction, has to always go in this preferred ideological direction?
Let me move to the next and what may be the last subject that I want the panel to concentrate on, which is something closer to home, which is, to what extent does international law affect our actions with respect of Guantanamo Bay, military tribunals, and the indefinite detention without charge of the detainees at Guantanamo? Who'd like to start on that?
I would. Okay. It's the challenge of trying to address the topic that launched 1,000 articles and lawsuits in a brief period of time. I think I want to use it as an occasion to sort of, again, speak a little bit systematically about how this law actually comes up in court, for example, or not. So the question was, how does this affect U.S. conduct? And there is a great body of literature that says governments care about what the law is, and it affects, or at least makes them think about their conduct, whether or not it ends up in court. And I think there's a nice body of evidence and anecdote that supports that view. But let me just cabin that question and focus on, well, they certainly care about it to the extent that it comes up in U.S. domestic courts, and all of these things that we just listed have come up in U.S. domestic courts a great deal over the last decade plus. So here, let me just give one example, if I can, in this setting of how this body of law, in particular with a lot of these things, we're talking about the law of war, again, also called international humanitarian law, the law of armed conflict. This is the law that is captured by the Geneva Conventions primarily, their additional protocol, and also some customary international law as well that the United States would recognize. So how does this come up? Okay, so we want to prosecute some of these guys for war crimes at the military commissions at Guantanamo. We charge them with some offenses, like material support for terrorism. The Court of Military Commissions down there says, well, is that an offense under the law of war, material support for terrorism? Most, right, international lawyers say, no, that's not an international criminal offense. You know, how do you know what counts as an international criminal offense? Well, in the first instance, we now have a statute, the Military Commissions Act, that says here are the charging offenses we're going to pay attention to. But that wasn't passed until 2006. How do you prosecute these guys who were engaging in bombing or attempted bombings or whatever it was in 1996, 1998, 2000, 2001 under a 2006 statute? And the DC Circuit recently, and Judge Kavanaugh among them, said, well, you can't do that. The question is, what did international law say was a crime under the law of war before 2006? And for that purpose, because the Military Commission statute says that's the body of law you have to look at, our own Military Commissions Court, the Court of Military Commissions Review, and then ultimately the DC Circuit so far, looks to international law to help decide what counted as a war crime when the United States launched its tribunals in 2001. Similarly, our statute, the Military Commissions Act, says, look, military commissions only have jurisdiction over offenses that occurred during hostilities, and the statute has particular language in connection or associated with hostilities. The Act, our federal act, defines hostilities to mean any armed conflict subject to the international law of war, right? So it is incredibly common, particularly in this field, post 9/11, for there to be a direct incorporation by reference by Congress, and the courts have sometimes implied that reference where Congress hasn't been explicit, to say, go look at this body of law. Now here's where decision-making bodies matter, right? Some of the most authoritative, not binding on our Court of Military Commissions, but most authoritative opinions interpreting the scope of international war crimes have come out of international courts to which the United States was not a party. So the Special Tribunal, the Special International Criminal Court for the former Yugoslavia, for Rwanda, that was created by the UN Security Council with US support, created these courts to try war crimes following those conflicts. And those courts, in learned and lengthy opinions that are broadly available, said, well, here's what we think this crime means. And our Court of Military Commissions in Guantanamo, the DC Circuit most recently, has looked very carefully at those opinions. Our government invokes those opinions by saying, here's what we think it means hostilities, right? Here's what we think the international law means hostilities. Now nobody, and none of the courts and the executive who has invoked those opinions think that they are in some sense legally binding, but they have proven to be incredibly authoritative because they've drawn on the evidence one looks to in international law, treaties if they're applicable, other courts that have interpreted those treaty provisions, including domestic courts, and the opinion of expert bodies and the opinion of the ICRC, and has crafted a persuasive judicial opinion saying, here is our interpretation of the meaning of this term. These days, the vast majority of decisions, certainly coming out of the military commissions to do with Guantanamo and so forth, are addressed by our domestic courts, applying to some extent our domestic law and to a great extent international law, whether that law is captured by treaties or customary international law. Now, to the extent you buy the role of the courts and the power of the courts to interpret the law, that is precisely what they're engaged in. In these cases, the law just happens to be international in nature rather than solely domestic.
Brian?
So I wanted to address the very question of are states, or is the United States influenced by some of customary national and international law with respect to these kinds of questions, especially in wartime. So my view of it is that, in fact, the U.S. military does comply with the laws of war in general, especially as a matter of policy, though there might be aberrations or rogue actors in Abu Ghraib as examples of that, and that, in fact, it serves our interests. So at the same time, I think it serves our interests if, in fact, we do abide by a common set of rules and try to impose those rules on the rest of the world, and that they're static, that they don't get changed by one administration ratifying a treaty and then another administration taking us out of that treaty. I don't think the U.S. military would appreciate that kind of instability. I think the U.S. military wants the Geneva Conventions, the laws of war, and for them to remain static. And that it is the case, I also agree at the same time, that certain NGOs have tendentious arguments as to when the laws of war apply and when they don't apply. And just to give you a kind of a checklist, I've once written about this, the issue of military commissions. So a number of civil libertarian groups and NGOs said the laws of war don't apply to the conflict with al-Qaeda because if they did, then military commissions would have jurisdiction. So they said we're not at war. When POWs came up and the question of tribunals to determine status, they said they do apply. They were in an armed conflict, and therefore these individuals deserve a tribunal or a status determination. Where do you find that? The POW Convention. Then the question came up about legal counsel. They said it's not a war. It doesn't apply, because if we're in a war, detainees or POWs don't get legal counsel. You get that if you're not in a war. Then the issue of fair trials came up. They said we are in a war, because if it's a war, then Common Article 3 applies. And that's what the Supreme Court accepted. Common Article 3 applied, and then invalidated U.S. military commissions at the time. Next issue came up, targeted killing. Targeted killing, I said it doesn't apply. We're not in a war, because targeted killing would be permitted in wartime, but if it's the human rights regime outside of war, then we consider that to be extrajudicial killing. So kind of flipping back and forth. So you can see that, and I think those arguments can be exposed for what they are, but the right approach, or at least the approach that I would say is the most advisable one, is consistency. Consistency in accepting that sometimes the laws of war will have certain kinds of benefits and certain kinds of constraints with respect to policy choices. But I would predict that if one were to ask legal advisors to the U.S. military whether or not they think it should be static, so that it's not removable by different administrations coming into power, they would think that it's best for the U.S. Its own compliance with the laws of war, for us creating a certain set of rules that are fair rules of the game, that the concern that we really have is asymmetrical wars in which our enemies don't abide by the laws of war. And if anything, when I go to certain conferences of military legal advisors from around the world, what I generally see is the U.S. military legal advisors saying, let's change the conversation to be about, or direct the conversation to be about, what do you do to comply with the laws of war? Because they know that we kind of operate with best standards. And that's the kind of approach that I think that's where they're at. They aren't troubled by these rules in any large extent. Just by last point, way of example, I think it's fair to say most international legal experts would say the Rome Statute for the International Criminal Court, its codification of what counts as a war crime, is supposed to reflect customary international law. Those articles were largely just taken from the U.S. State Department. The U.S. State Department said, here's what we would accept as the elements of these crimes, because we don't have any trouble with them. We don't think that they undermine our ability to win wars effectively. Just by way of example, we have other concerns with the International Criminal Court adjudicating those rules, and that's kind of what we've kind of gotten into in this discussion. I think in terms of the rules themselves, we have to think of them a little bit differently.
Well, the subject matter is so complicated we could be here all afternoon, but I did want to allow some time for questions. Are there any questions from any of the members of the public? Please identify yourself and keep the question short and make sure it's a question. Would you please?
Yes, sir. Ken Davis, Richmond, Virginia. For any member of the panel, does the self-characterization by ISIL as a state, does that change just by the assertion? Does that change their classification or the treatment or the analysis of the rules of engagement with them, or just raise a further question?
If by merely saying they were a state meant they were a state, then the answer to that would be yes. If they in fact were a state, it does change things. However, merely by saying you're a state doesn't make it so. And so as a result, I don't think that the answer to that would be no. I think everybody would agree that just because they say they're a state doesn't mean it changes the laws applicable to how we can enter into a conflict with them.
I might just add that you put your finger on what has been probably the most difficult question for the United States and its relations with the rest of the world in dealing with terrorism for the last 14 years, and which was resulted in I have spent hundreds of thousands of hours in discussing these issues with the European governments how do you classify a non-state group? Because non-state actors are not parties to treaties. So, for example, the Geneva Conventions don't apply. But what law then does apply? And, for example, I just got back recently, a couple of weeks ago, from Brussels, speaking to Europeans now that the ISIL crisis has been going, and I think they now realize that, in fact, what they thought were sort of relatively easy legal issues of dealing with terrorism, where many European countries thought that you just dealt with terrorists as a law enforcement matter, they now suddenly realize, well, this is actually much more complicated than we thought. It wasn't just that the United States was breaking all the rules. We now see that here is a group to which no law applies to regulate them. We can't send extradition requests to Syria or Iraq to say, please send these people over. We can't prosecute them in our own local courts. So this has been a huge issue between the United States and other countries as we have tried to educate other countries on the rules that we are applying, often without a lot of agreement. But the ISIL issue has now begun to focus attention in ways that were not previously, I think, understood outside the United States. So it's a good question.
Thank you.
I just wanted to make a few points, too. One, I think, is that the basic thing that should apply in terms of laws of war to these kind of groups is reciprocity. I mean, even if ISIL weren't a state, I think they could say we will abide by the Geneva Conventions. Even the Geneva Conventions provides for that. But if this is a group that is, from every evidence, doesn't feel like applying the laws of war at all in its conduct, then I don't think the United States should fight with one hand behind its back and say, we're going to comply with the Geneva Conventions as if you were a state, right? That's effectively what we would be doing. The second thing about the targeting, I don't think that the customary rules on targeting, how you discriminate, how you use proportional force would be different, but I think how you apply them would be different. I think that's something I don't think the other speakers address, is that I think ISIL, given, again, the way it fights, if they are intermixing military targets with civilian targets, if they're disguising or hiding military assets within civilian buildings, I think that's very characteristic of these kinds of groups. And so I think that the laws of war would have to be applied differently, even in their customary form, to these kinds of groups because of the fact they don't comply with the laws of war. The primary one is to distinguish the military and civilian targets from each other so that you don't invite attacks on civilians. But I think these groups deliberately do that on purpose because they want to increase civilian targets and use them, civilian casualties, and use them for propaganda purposes.
Next question.
Yes, thank you, Mr. Chairman. My name is Briard. I'm the chair of the Paris chapter of the Federalist Society. I'd like to make a 2-minute remark about a source of international law to Europeans, which is not about treaties, not about customary rules. It's about case law and jurisprudence. I'd like to remind you that Europeans are under jurisprudence made by the Court of Luxembourg and the Court of Strasbourg. And this is about interpreting international law, the European Convention of Human Rights and the EU treaties. And it is more than binding for us. All domestic rules have to differ. All domestic courts and parliaments have to respect that jurisprudence. So to Europeans, jurisprudence, case law, is a huge source of international law. This is what I wanted to mention. Thank you.
Thank you very much, Henri.
That doesn't mean it's a good thing.
Hi, I just had a question about the applicability of use cogents in a practical application of it. Is it merely turned into a rhetorical flourish to like bang your hand on the table and say, this is not only a violation of customary international law, it's also a violation of use cogents, or does it really have some substantive effect? Thank you.
Anybody in particular you want to ask that to? Sure. Anybody in particular?
I can take
it. Right.
Sure. I want to answer that question, then just say something about what John, you had just said. So yeah, use cogents is a subset of customary international law, and it's supposed to be a kind of a higher order, so that there are particular norms from which no state should ever be able to contract out of, is one way of thinking of it. So it could include, for example, slavery, genocide, and the like. And I think, unfortunately, it's part of the rhetoric or discourse of international law because it makes groups and organizations, institutions, including the Security Council itself, think that it has to call something genocide because then it triggers a certain kind of political effect, not necessarily a legal effect. And then if they call something a crime against humanity, well, maybe a crime against humanity is not a use cogents. And so I think that's part of the problem that's entered into these kinds of discussions, in part because some of these institutions have become quite powerful. And when I'm thinking about the Security Council, I'm thinking about referrals to the International Criminal Court. So use cogents is an important component of that. And then just to also tip my hat in a certain sense to some of the things that John Hughes said with respect to the in-American human rights system. There's some jurisprudence that says discrimination is use cogents. Now, and a systematic discrimination. I think systematic discrimination is a customary international law violation, yes, but use cogents is kind of very well reserved in a certain way. And it might be that it's a good idea for that to be the case, but I don't think states would have signed up to that. I just want to say one reaction to what John had said with respect to the kind of the terrorist groups that are intermingling their military forces and rockets and the like with civilian structures. Where I disagree very much with the statement that therefore you kind of need to abandon the laws of war or find a different kind of rule, is that I wouldn't think the Israeli government would say anything like that. I think the Israeli government would say, we abide by the rules of law, and that the laws of war take into account that that's a legal violation of the terrorist group to do that, but the way in which they conduct their military operations is fully compliant with the laws of war. Because if we suggest that the laws of war don't allow for those kinds of strikes, I think logically speaking, the next inference has to be, well, then the Israeli government is not abiding by the laws of war. And I just had a discussion yesterday with one of the members of the MAG from the Israeli IDF. That's certainly not their position, and I think that we need to be careful if we suggest otherwise.
I have to apologize. I've gotten the hook. And please join me in thanking the panel for the conversation.